Some pro se litigants are very effective at representing themselves, others are less effective.
This is a case of the latter.
Viva Frei, Montreal litigator turned YouTuber, and this is Winnie the Westie, who is long overdue for a bath, and there is an update in the Tim Pool Subverse lawsuit, and I'm bringing it to you. For those of you who are new to the channel or have not seen my 2 previous vlogs on this lawsuit, just a 30,000-foot overview of the lawsuit. A while back, Tim Pool started a new company called Subverse, and apparently they raised something like over $1 million crowdfunding on the internet in over 24 hours. Molli is one of the defendants to the lawsuit. The other defendant is an individual named Rocco Castoro, who was never a shareholder in the company, was apparently might have been a director, but probably wasn't, and they were both terminated, allegedly for wrongful conduct. They were allegedly disseminating information that was apparently, purportedly, potentially defamatory. They were allegedly misappropriating the funds that were raised by the company for their own benefit, and they apparently made off with a bunch of assets that the company purchased, such as equipment for videography and stuff. After they were terminated, however, Molli apparently convened a director's meeting with Rocco Castoro in which they apparently removed Tim Pool as a director of Subverse. They attempted to remove Tim Pool from his own company. Apparently they never gave back the assets that they allegedly misappropriated, and Subverse filed suit. I broke down the initial claim. It is indeed a very interesting lawsuit to read because some of the exhibits filed by Subverse do not make the defendants look particularly good, and it looks like the defendants did a very fine job preparing the evidence on behalf of the plaintiff. The defendants apparently were self-represented for whatever the reason, and they just filed their answers, their defenses to this lawsuit, and I tell you, their defenses quite literally appear to be a dog's breakfast. Now, full disclosure, I'm a Quebec attorney, so I don't know all of the proper procedure in the United States, so I don't know, maybe I'm missing something in terms of what is going on here, but they seem to have filed 2 separate documents in their respective defenses, but not in their individual defenses. They both seem to be the defendants in both of these documents, and my feeling is that one of these documents is the one they found online for pro se litigants, pro se being self-represented for those of you who don't speak that type of Latin, and the other one is the one they put together from that document that they pulled from the internet. So they basically have 2 documents in their defense as their pleas, as their answers, as their defenses to this lawsuit. And when I say it's a dog's breakfast, it's because it's a dog's breakfast. These proceedings are confusing. They have paragraphs that go on forever. They include details and information that presume a level of knowledge that I don't think any judge on earth is going to have, because I think they're making allegations that don't appear anywhere in the plaintiff's claim itself. It is the curse of presumed knowledge. It is the curse of not knowing what to allege, what to omit, and as a result, it is utterly confusing what they are alleging in their defense. But the bottom line of their defense, in as much as I have been able to whittle it down, is that they did not misappropriate the assets they are alleged to have misappropriated. They have always wanted to give them back, but they have been unable to do so. They did not misappropriate the funds in the bank account, and they did not hold a bogus director's meeting to attempt to remove Tim Pool from his own company
and take over Subverse.
Now, when I say that I think Molli and Rocco Castoro basically filed 2 documents because they got inspired from the form they found online, this is why. The first document that they filed on the upper left corner says pro se forms. Pro se 3 Rev 1216, the defendant's answer to the complaint, United States District Court for the District of Connecticut. And here we can see that it is something of an online form with sections to be filled out by pro se defendants, as the defendants seem to have done here. On page 3 of 7, you can see that it says asserting affirmative defenses to the claims for relief, and then you have a list of affirmative defenses. And then when you go to the other court filing that these defendants filed, you can see all of those affirmative defenses drafted into the defense itself. Specific affirmative defenses. First affirmative defense, failure to state a cause of action. The complaint and each cause of action therein fails to state facts sufficient to constitute a claim of relief against defendants. Second affirmative defense, forum nonconvenience. Forum nonconvenience basically means that they did not file the lawsuit in the proper form, so the defendants are seeking the dismissal of the suit so that it can be refiled in the proper form, but wait until you read the justification in this paragraph. Defendants allege that the complaint and any counterclaims thereto should be tried in a different form because an adequate alternative form is available. The relevant public and and private interests weigh in favor of dismissal, the plaintiff can reinstate its suit in the alternative form without undue inconvenience or prejudice. Notably absent from this allegation is why it is the inappropriate form and what the appropriate form would be, and we're just going to go through the other affirmative defenses very quickly before getting into the factual allegations in their defense. Laches, the complaint, and each cause of action therein are barred by the doctrine of laches and undue delay in giving notice to defendants of the matters asserted in the complaint and in commencing this litigation. Privilege or justification. The complaint and each cause of action therein are barred because both by statute and by common law, defendants were privileged and justified in acting as defendants did and in making the statements and representations defendants made to the persons to whom the statements and representations were made. Moreover, any and all conduct that is attributed to defendants involved a just and proper exercise of management discretion undertaken for fair and honest reasons and regulated by good faith under these circumstances. Any purported injury to plaintiff was privileged by a countervailing interest of defendants. Accordingly, defendants cannot be liable for plaintiff's damages, if any there be. And it goes on and on and on, and I mean literally on and on and on. Fifth affirmative defense, waiver. Sixth affirmative defense, estoppel. Seventh affirmative defense, consent. Eighth affirmative defense, unclean hands. Ninth affirmative defense, failure to mitigate or report. 10th affirmative defense, good faith. 11th affirmative defense, legitimate business needs. 12th affirmative defense, no willful or unlawful conduct. 13th affirmative defense, unconstitutional recovery. Although defendants deny that defendants have committed or have responsibility for any act that could support the recovery against defendants in this lawsuit, such recovery is barred, if any, to the extent any such act is unconstitutional under numerous provisions of the United States Constitution and the California Constitution, including the excessive fines clause of the 8th Amendment, the due process clauses of the 5th Amendment and Section 1 of the 14th Amendment and other provisions of the United States Constitution, and the excessive fines clause of Section 17 of Article 1, the due process clause of Section 7 of Article 1, and other provisions of the California Constitution. And there's one more affirmative defense, the 14th affirmative defense. Defendants are entitled to set off and recoupment for monies owed by plaintiff to defendants such that any offset amount is cancelled and defendants is only obligated to pay plaintiff the net amount of his damages, if any. All right, now that we've gone through the 14 affirmative defenses and you can make what you will of those affirmative defenses, the defendants also respond specifically to certain specific allegations in the lawsuit itself, more specifically the allegations that they allegedly broadcast or disseminated allegedly private and potentially defamatory information. In answer to paragraph 4 of the complaint, defendants deny that they were terminated because they, quote, began broadcasting information they knew to be private information from a third party that they knew could be defamatory and or false, end quote. In fact, defendants were wrongfully terminated by plaintiff due to their raising numerous complaints about Timothy Poole's unlawful conduct. All right, so for anyone who may be new to the channel and hasn't heard this before, these are things we've discussed in previous vlogs, but when you file a defense to a lawsuit, typically you need to respond to each and every allegation in the lawsuit itself, either by admitting, denying, having no knowledge of, or clarifying those allegations, because if you do not respond to those allegations, it can be deemed to be an admission of those allegations. In law, this is what we call juridical weak sauce, because they did not actually address anything of the substance of the accusation or the allegation against them. All they did was issue a blanket denial and then go on the attack to say that they were fired for allegedly reporting on the unlawful conduct of Tim Poole. We will see what a judge or a jury thinks of this blanket denial with no more substance than that, but wait until you get to their explanation as to why they have not returned the property they allegedly misappropriated. With respect to the return of plaintiff's, quote, assets, end quote, defendants have attempted to work with plaintiff to return certain physical equipment, but due to certain acts or omissions by plaintiff, Poole and other purported agents have been unable to do so. Defendants deny that they had any, quote, intent, end quote, to, quote, hijack the plaintiff company and its sick website for their own purposes, end quote. Defendants admit that Molli is a shareholder of plaintiff. Implicit in this allegation is that they do in fact have the assets, and they seem to be admitting that they have no intention of keeping them, so I guess that's going to be relatively easy to resolve as an outstanding issue. With respect to the allegation of having misappropriated or spent funds in the company bank accounts, this is what the defendants have to say. In answer to paragraph 19 of the complaint, defendants deny only Molli, not Castoro, had access to plaintiff's bank accounts until January 6, 2021. Defendants never used plaintiff's money, quote, as if it were their own, end quote. Similarly, Molli never used plaintiff's money, quote, as if it were her own, end quote. Defendants deny that Molli made, quote, unauthorized withdrawals and gave money or hired individuals, end quote, against the wishes of, quote, plaintiff's senior management, end quote. So far, pretty par for the course. We didn't steal any assets, we just have them and we're willing to give them back. We didn't spend money without authorization, we had the authorization to spend it, but wait until you see the admission made at paragraph 23. In answer to paragraph 23 of the complaint, defendants admit
Admit.
Now, in law, in pleas or defenses, denials are pretty much par for the course. You expect the defendant pretty much to deny each and every allegation that can be plausibly denied. So when there's an admission, you have to stop, pause, and go see what exactly was just admitted to. Paragraph 23. On or about March 1, 2021, the defendants Molli and Castoro attempted to remove Tim Pool as the plaintiff's chief executive officer, during which they attempted to make defendant Molli the new CEO. A copy of the minutes of that, quote, meeting, end quote, was sent via electronic mail to Tim Pool on or about March 1, 2021. Okay, so the defendants just admitted that they did in fact convene a meeting just between the two of them, during which they attempted to remove Tim Pool as CEO of the company to replace him with Molli herself. With that admission in the court record, let's just go see what exactly their explanation was as to why they convened that meeting. Defendants took this action in response to Pool attempting to remove Molli from the board in an illegitimate board meeting and obstruct ongoing investigations by the U.S. Securities and Exchange Commission and Federal Bureau of Investigation. Alright, so the defendants are basically admitting to having done what they are alleged to have done, except their defense is that they did what they did because Tim Pool wrongly terminated Molli, apparently as a reprisal for her having filed a claim with the SEC and the FBI, and their only course of action was to convene a meeting between the two of them, during which they attempted to oust Tim Pool as CEO of Subverse.
Okay, try to digest that.
So that is Emily Molli and Rocco Castoro's defense, and my goodness, I don't think they're doing themselves any favors in what they filed with the court, but only time will tell.
But I think I'm going to stick with that prediction.
With that said, if you like my videos, you like my content, please be sure to like, share, subscribe, hit the notification bell, and drop a comment in the comment section below because it feeds the algorithm. If you want to support the channel, all of the support links are in the pinned comment. Robert Barnes and I do weekly streams every Sunday. We do weekly streams with a guest every Wednesday called The Sidebar. If you want to find us and support us at Locals, you can find us at
VivaBarnesLaw.locals.com.
All of my content is also on Rumble if you want to find it there, but more important than anything, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out. Booyah!